Burrows, Principal of Dundas Lawyers. Dundas Lawyers is an award-winning corporate, technology, intellectual property law firm based in Brisbane with clients throughout Australia. This video I'm going to talk about what constitutes a breach of computer code, copyright in computer code. I'll give a couple of examples of recent cases from the courts and summarises what's known as the idea-expression dichotomy, which is central to our understanding what is protected by copyright law. So in Australia, computer code, like other literary works, are automatically protected by copyright. Generally, the reproduction of another programmer's code without their consent amounts to an infringement of copyright. However, what's important to understand is it's the material expression of the code, that is the written code, not the function that the code performs that is protected. In the recent case of TICA default tenancy controls and data catch, there were 3 ex-employees that had resigned and they'd set up their firm called Data Catch. This isn't an unusual situation either, by the way. In doing so, they built software to perform essentially the same function as the software used and promoted by their former employer. On the testimony of an expert witness, the court found that it was most unlikely that the code was directly copied between the 2 applications, and therefore there was no breach of copyright. Separately, on a separate cause of action, of course, the TICA was successful in prosecuting for a breach of confidence, which is a separate right altogether, but it's important to note that point. Then we have to contrast that case with IPC Global and PAVE test. In that case, code was copied from a dynamic link library and a number of test modules from IPC software, which consisted of about 250,000 lines of code. On the testimony of an expert witness again, the court found that there were specifically 800 lines of PAVE test's code that were identical to IPC's code, and therefore the argument was made that between 10 and 20,000 lines of code could have been copied. The case highlights that even copying a small proportion of the code can lead to a copyright infringement. It's a myth that you have to copy a certain percentage. So these 2 cases do a good job of highlighting the idea-expression dichotomy that permeates copyright law. It's the idea is not protected, only the expression of the idea in material form is. So Data Catch produced the function of the software without copying the code itself, and therefore they hadn't infringed the copyright. Conversely, PAVE test reproduced IPC's code in its material form, and as a result were effectively guilty of directly copying it. Although it's important not to forget that TICA was successful in prosecuting for breach of the obligations of confidence. So there are very often various causes of action to be considered in any sort of copyright matter when you're attempting to enforce or protect your rights. So if you're looking for a technology-savvy law firm to advise you on any civil and intellectual property law matter, don't hesitate to give me a call on 3221 0013 for an obligation-free and confidential discussion. Thanks for watching.